Hello to you all and welcome to the lesson. The subject is company law. We're going to begin revising the paper that was done in April 2022 by the CPA and certified secretaries. Now, the paper has 7 questions. Candidates were to answer 5 questions. Time allowed 3 hours. We'll be answering a question at a time. In every session, we'll be answering 1 question. For example, in this session, I'm going to answer question number 1. The next session, I'll answer question number 2. Like that until we answer the 7 questions. It's my hope you're ready to revise. I urge you to be looking at the questions before attending these sessions. Make sure you answer the questions on your own first. Let's begin with question number 1, part A. Highlight 6 ways in which a person may become a member of a company. 6 marks. Highlight 6 ways. Company Law, April 2022, question 1A. 6 ways in which a person may become a member of a company. 6 ways in which a person may become a member of a company. The first way is through subscribing to the memorandum. Subscribing to the memorandum. Now, the subscribers to the memorandum are deemed to have agreed to become members of the company, and on its registration, their names are entered in the register of members. That's the first way. The second way is through allotment. Allotment is the second way in which a person may become a member of a company. A person to whom shares are allotted by the company pursuant to an application on flotation becomes a member when his name is entered into the register of members. The third way is through transfer. This is the purchase of shares from a willing member, that is, the transferee becomes a member when the transfer is registered and his name entered into the register of members. So if I'm a member of company A and I'm willing to sell my shares to you, to transfer my shares to you, then you can become a member of company A through transfer, which is the purchase of shares from me, a willing member of the company, who would willingly transfer the shares to you after you pay through a stock broker. Transfer. Then there is transmission by death. Transmission by death. Transmission by death. Now, the shares of a deceased member pass to the person, or I can say the shares of a deceased person, this is a person who has died, may pass to the personal representative by operation of of law, by operation of law. So transmission by death. So if one dies, then the personal representative of the one who has died becomes a member of a company through operation of law. 5. Transmission by bankruptcy. Transmission by bankruptcy. Now, under the provisions of the Bankruptcy Act, the shares of a member declared bankrupt by a court of competent jurisdiction pass to the trustee in bankruptcy. So transmission by bankruptcy is another way in which a person may become a member of a company. The 6th way is share qualification of directors. Share qualification of directors. Share qualification of directors. A person who has delivered to the registrar an undertaking to take and pay his qualification shares is deemed to be in the same position as a subscriber to the memorandum for that number of shares. So share qualification of directors is another way in which a person may become a member of a company. There are many ways other than these 6, like estoppel, through the doctrine of equitable estoppel. Equitable doctrine of estoppel. A person can also become a member by agreement to become a member and entry on the register of members. So these are 6 ways. 1, subscribing to the memorandum through allotment, through transfer, transmission by death, transmission by bankruptcy, share qualification of directors. 6 ways, 6 marks. 6 ways, 6 marks. I'm going to answer part B. Identify 4 types of particulars to be registered with respect to a company's beneficial owner. Types of particulars to be registered with respect to company's beneficial owner. Company's beneficial owner. Who is this owner? Beneficial owner. Now, candidate's beneficial owner means the natural person who ultimately owns or controls a legal person or arrangements, or the natural person on whose behalf a transaction is conducted. And beneficial owner includes those persons who exercise ultimate effective control over a legal person or arrangement. The question is, what are the types of particulars to be registered with respect to a company's beneficial owner? Number 1, full name. Number 2, identification card, that is personal identification card or national identity card. The national identity card number, national identity card number. Or it can be passport number. Then there is personal identification number, popularly known as PIN. Full name, national identity card, also known as the ID, the personal identification number, also known as the PIN, telephone numbers, telephone numbers is another type of particular to be registered with respect to a company's beneficial owner. Telephone numbers. If one has telephone numbers, there is current email address. All right. Current email address. Another particular is occupation. What is the occupation of the beneficial owner? Is it a teacher, a carpenter, a videographer, an accountant? What else? What else? Current email address, occupation. The other particular is the date on which a person became a beneficial owner. The date on which a person became a beneficial owner. The date on which a person became a beneficial owner. Another one could be the date on which any person ceased to be a beneficial owner. The date on which a person ceased to be a beneficial owner. The date. So you have to identify just 4. There are many particulars candidates. They are not 4. They are not 8. They could be 10. Like we can add any detail. Or let me say the name of ownership control. The name of ownership or control, because we are talking about beneficial owner. The nature of ownership or control. All right? The nature number 9, nature of ownership or control. The nature of ownership or control. So these are some of the types of particulars to be registered with respect to a company's beneficial owner. Full name of the beneficial owner, the national ID of the beneficial owner, the PIN, telephone numbers, current email address, the occupation of the beneficial owner, the date on which the person became a beneficial owner, the date on which the person ceased to be a beneficial owner, the nature of ownership or control. Any 4 here would earn 4 easy marks. These are 4 easy marks. For any 4 points, 4 easy marks. Let's move on to answer part C, which says A person dealing with the company is entitled to assume, in the absence of facts putting him in doubt, that there has been due compliance with all matters of internal management and procedure required by Articles of Association, with reference to the rule in Royal British Bank versus Taquant. Summarize 5 exceptions to the above statement. Exceptions to the Taquant rule. Now, before we answer, we'll put down the exceptions. It's important for us to revise what is this rule, the Taquant rule. Now, learners, the Taquant rule is a rule that came about as a result of the case between Royal British Bank versus Taquant. And Taquant was the official manager or the liquidator of the insolvent Camerons, Colebrook and Swansea and London Railway Company. And it was incorporated under the Joint Stock Companies Act. The company, this company, had given a bond for 2,000 sterling pounds to the Royal British Bank, which secured the company's drawings on its current account. The bond was under the company's seal, signed by directors and the secretary. So the company alleged that under its registered deed of settlement, which is just the Articles of Association, directors had no powers to borrow. All right? The directors had what? The directors had powers to borrow what had been authorized by the company's resolution. Do you understand? The company, which had borrowed money from the Royal British Bank, alleged that under the Articles of Association, directors had powers to borrow what has been or what had been authorized by the company's resolution. And a resolution had been passed, but not specifying how much the directors could borrow. So the company, in this case, claimed that there was no resolution passed authorizing the issue of the bond, and that therefore the company was not liable. So you see the case pitting, that's the case pitting the Royal British Bank and Taquant. Taquant was the liquidator of the insolvent Cameron, Colebrook and Swansea and London Railway Company. So this company borrowed money from the bank through a bond, which secured the company's drawings on its current account. So the company failed to repay the money under the argument that there was no resolution that was passed authorizing the issue of the bond, and that therefore the company was not to be liable for the 2,000 sterling pounds. And it was held that the company was entitled to sue on the bond, as the requirement for the resolution was a matter of internal regulation for the company, and the bank could not know whether such resolutions had in effect been passed, and it was entitled to presume that the resolution had indeed been passed. That's why this law or this rule is also known as the rule of indoor management. The indoor management rule. It is on the basis of this rule which I read, a person dealing with a company is entitled to assume, in the absence of facts putting him in doubt, that there has been due compliance with all matters of internal management and procedure required by articles of association. With reference to the rule in Royal British Bank versus Taquant, summarize 5 exceptions to the above statement. What are the exceptions? The rule is that people dealing with the company ought not to bother much whether the company has complied with its internal policies or complied with the articles of association. The court held that the company was entitled to sue on the bond, as the requirement for the resolution was a matter of internal regulation for the company. And the bank could not know whether such resolutions had in fact been passed. The company was entitled to presume that the resolution had indeed been passed. So what are the exceptions to this rule? One is where an outsider has information or knowledge of irregularity. Outsider has knowledge of an irregularity. Where an outsider has knowledge of an irregularity, then that will be an exception to the Taquant rule. The first and the most obvious restriction is that the rule has no application where the party affected by an irregularity had actual notice, all right, had actual notice of the irregularity. And knowledge of an irregularity may arise from the fact that the person contracting was himself a party to the inside procedure. For example, in this case, if the bank had knowledge of the going-ins, the workings or the internal affairs of the company, then the company could not be entitled to sue on the bond. So this is an exception to the Taquant rule. The second point is suspicion of an irregularity. Suspicion of irregularity. Now, the protection of the Taquant rule is also not available where the circumstances surrounding the contract are suspicious and therefore invite inquiry. And suspicion should arise, for example, from the fact that an officer is purporting to act in a manner which is apparently outside the scope of his authority. Number 3, forgery. Forgery. Forgery may, in circumstances, exclude the TAC1 rule. For example, the company secretary who affixes the seal of the company and forges the signature of the directors and goes ahead to issue the certificate. That will, the TAC1 rule in such a case will not apply. Forgery. 4, representation through the articles. Representation through the articles. Now, the exception deals with the most controversial and highly confusing aspect of the TAC1 rule. And the articles of association generally contain what is called the power of delegation. The effect of the delegation clause is that a person who contracts with an individual director of a company, knowing that the board has power to delegate its authority to such an individual, may assume that the power of delegation has been exercised. And to that effect, the exceptions, that becomes an exception to the TAC1 rule. Number 5, acts outside apparent authority. Acts outside apparent authority. Now, if the act of an officer of a company is one which would ordinarily be beyond the power of such an officer, the plaintiff cannot claim the protection of the TAC1 rule simply because under the articles, power to do the act could have been delegated to him. In such a case, the plaintiff cannot sue the company unless the power has in fact been delegated to the officer with whom he dealt. With whom he did what? With whom he dealt. So these are 5 exceptions to the TAC1 rule. 1, 2, 3, 4, 5, 10 marks. 10 marks. And that effectively brings this lesson to an end. We've answered question number 1. In our next class, we are going to answer question number 2, which is in 3 parts, A, B, C. Please try and attempt question 2 before attending the next session. Thank you. God bless you. Bye-bye.